What if I told you that there is a legal way to settle or discharge your debt using private trust or an entity? What if I told you that you can do this without paying the full amount, without going to court, and without ruining your credit? In this video, I'm going to be breaking down how trust and private contracts can be used as powerful tools in the world of finance, debt settlement, and asset protection. And I'll show you the laws that support it. Now, first things first, man, I've studied debt law, trust law, and commercial code, and I'm here to expose the strategies that most people will never hear from a lawyer or a bank. And also at the same time, even though I have that knowledge and that education, this is not legal advice. This is only for educational purposes only, okay? So if you tapped into this video and you're looking for legal advice, I will tell you to go tap in with an attorney or a legal aid in your state, all right? But before we dive into the information, okay, before we break down this game that nobody is talking about, make sure to hit the like button, all right? You hit the like button, I'll keep dropping more bangers like this. Also, at the same time, if you're brand new, make sure to hit the subscribe button and turn on the post notifications so that you can get a notification and an update every time I post a video. All right, now let's go ahead and dive straight into it. Okay, let's talk about what a trust or a private entity is. Okay, now a trust is a legal relationship where one party, trustee, holds the property or authority for the benefit of another, which is the beneficiary. So when we dive into any trust model, the beneficiary in this case will probably be you, and you would essentially give the trustee the property to hold onto and essentially manage, in a sense. Okay. Then we dive into a private versus a public trust. Okay. Private trusts operate under contract law and don't require state registration. You dig me? Now, private entities can include common law trust, private membership association or PMAs, unincorporated business organizations, and foreign grantor trust. All right. So a lot of times when we think about the trust, in a sense, or we think that the only way that a trust is, the only trust we can think of is the SKV trust, the trust that's with the Federal Reserve, the trust that's attached to your SSN. And understanding this could be able to bring some type of understanding to those concepts and how debt discharge works in the trust sense. But you can create your own trust. Okay, a lot of times people won't tell you that you can go to the IRS website and create your own trust. There's no point in you spending thousands of dollars for somebody to create a trust for you. Okay, I'll do a separate video on how to do that at a later date. But if you just do a simple Google search, creating a trust, you can go online and create it. Now, let's talk about how a trust or a private entity can handle debts. Okay, number one, the trust assumes the obligation. All right. If you transfer the obligation into the trust and the trust becomes the negotiating party, you can use a declaration of trust plus assignment to redirect the liability. So this becomes super essential when you are in a situation where you want to get certain obligations or certain debts out of your personal name. Okay. In a sense, your all caps name is attached to a trust. Okay. Now you create your own trust, you could be able to transfer the obligation to that trust. And when you transfer the obligations to that trust, this makes utilizing negotiable instruments much more seamless, okay? Because you'll have that ownership over that trust and there's no mystique about it, okay? Then we dive into how a trust can settle via a private negotiable instrument, okay? So a trust can issue their own private bonds, promissory notes, or orders for set off under UCC 3-104 and under 3-603. So when we dive into UCC 3-603, which is the tender of payment, and then we dive into UCC 3-104, it talks about negotiable instrument, which means a unconditional promise or order to pay a fixed amount of money. Okay. Now understand, if you are essentially creating your own negotiable instrument, this now becomes a lawful tender. Okay. A lot of times banks will say that, okay, well, you cannot submit a remittance. You cannot submit a coupon. You cannot do this, that, and the third. But it says in here that a negotiable instrument is a unconditional promise or order to pay a fixed amount of money. So if you put on a letter, hey, I'll unconditionally pay this over a fixed amount of time, or I promise to pay something, even if you just wrote a small note, and I won't recommend people to just write a small note, but even if you did that, essentially an IOU it and sign it, it now becomes a negotiable instrument. As a matter of fact, it becomes a financial instrument to the bank. Okay, and that is something that they can monetize because the dollar is an IOU. You dig me? So when you create a negotiable instrument and you dive into the tender of payment, we dive into 3-603, which is the tender of payment. If a tender of payment of an obligation to pay an instrument is made to a person entitled to enforce the instrument, which is the negotiable instrument, the effect of the tender is governed by the principles applicable to the tender of payment under a simple contract. So now if it becomes a simple contract, this is something that essentially falls under the guidelines of contract law. And under contract law, there are certain obligations for both parties to be able to adhere to in order for it to be a valid contract. Okay? So, for example, if you contract with another person, they also have obligations and performances to adhere to you. And also at the same time, there should be some type of consideration. So let's dive back in. Okay, it says if a tender of a payment of an obligation to pay an instrument is made to a person entitled to enforce the instrument and the tender is refused, there is discharge to the extent of the amount of tender of the obligation of the endorser or the accommodation party having the right of recourse with respect to the obligation to which the tender relates. So essentially, you send a negotiable instrument through your private trust that falls under these guidelines of now you have created a negotiable instrument, your own private negotiable instrument, and they must also now follow the UCC and they have a performance under this to reply back either to let you know if they refused it or on the other end let you know if it's accepted. And regardless, there is going to be a discharge regardless if done properly. So if you pair the negotiable instrument with the tender of payment law, then essentially this says that you can satisfy your obligation lawfully. They'll say that, oh, this is not a lawful form of tender or legal tender. Well, it says it right here that you can provide a negotiable instrument, and if you provide a negotiable instrument, then they must accept it. If they don't accept it, then the refusal means discharge. That means they forfeit the right to collect. Okay? Then we dive into operating from the private side of the law. Most of us want to go private. Most of us want to be able to have or hold our own jurisdiction. Once you create a private trust, okay, if you go through your trust, you are now operating in the private. But understand, before you dive into this, you have to make sure you fully understand any and everything about trust law before you want to dive into this and expect to get the results that you want to get. Okay, this is not something that you can just do and it's just going to immediately work. You have to have that full understanding of the law, or else you're going to do this, and when they say, oh, you can't do this, you're just going to lay down. People don't lay down if they know the law. So you can know any and everything, and I can tell you all of this stuff here, but if you don't have the full understanding of this, then you will not make it work. Okay, so then we dive into understanding the right to contract. Okay, so essentially having the right to settle debt privately. And a lot of times you can do this outside of the UCC system. And so it says here under Article 1, Section 10 of the U.S. Constitution limits states' powers, specifically prohibiting them from making anything but gold and silver coin a tender in payment of debts, okay, from passing laws that impair the obligation of contracts, thus protecting private rights from state interference, okay? So what does this mean? You can, number one, do this outside of the uniform commercial system. You can settle debt privately, but also at the same time, you can establish conditional acceptance or create a private administrative process from the trust position. So you can do the same thing that I teach, but you can do this all through a trust and essentially execute this privately. This can give you some advantages, but again, this is not legal advice. Do your due diligence, okay? This isn't something that you necessarily need, but it does give you more leverage in that negotiation power, okay? Now, I'm going to talk a little bit about the aspect and the legal framework that backs this strategy up. Now, before we dive into this, again, this is not legal advice, okay? Before I dive into this legal framework, make sure to like and subscribe to the channel, okay? I think we have about 99% of people who watch my videos don't actually subscribe. So subscribe to the channel, all right? If you watch 2-3 videos or you are a part of my Instagram community, like the video, all right? So let's dive back in, okay? UCC 3-603, okay, essentially breaks down the aspect of the tender of payment discharges the obligation if it is refused, regardless, okay? If you accepted a discharge, but if you're going to refuse it, then it is discharge. Then we dive into negotiable instruments, which is UCC 3-104, which essentially says that notes and instruments can be used as payment, okay? Then we dive into UCC 3-305, okay? Wrong thing. Let's go back one, which essentially is defenses against enforcement, okay? So essentially, if there's a lack of holder in due course, then they cannot enforce an obligation that they have no legal standing over. Okay, then we dive into some trust law. Okay, and this is when we get into the meat and potatoes and the nitty gritty. Restatement third of trust essentially breaks down that trusts are recognized in equity and contract. Okay, a lot of people don't understand that the restatement of third and trust, okay, is actually a comprehensive work by the American Law Institute that aims to organize and explains the principle of trust law, offering guidance to trustees, lawyers, and judges, and superseding the restatement second of trust, okay? It organizes and explains trust law, okay? Supersedes previous restatements, guidance for professionals, all right? And the key things and the whole point of this is to help you understand the trust law aspect of things, okay? And they recognize equity and contract. Then we dive into Title 26, okay? 26 USC, subpart E, section 671 all the way down to 679, which pretty much breaks down trust law, okay? And essentially, it talks about the allowance of income, transactions, and control to be passed through trust, okay? Diving into trust income, deductions, credits, attributable to grantors and other as substantial owners, definitions and rules, reversionary interest, power to control, beneficial enjoyment, administrative powers, powers to revoke, income for the benefit of grantor, person other than grantor treated as substantial owner, foreign trust having one or more United States beneficiaries. So essentially, this backs up trust law to a T, and you can come here and get all the information in regards to that. A lot of times people will say, oh, well, this stuff isn't true. Well, just go look it up yourself, okay? We can spend all the time going through each and every section, but I would recommend you tap into this, get a full understanding, read every single thing. A lot of people come to me and say, well, where do I get started? Get started by reading. You dig me? If you read and you do your research and do your due diligence, then you'll have more of an understanding, okay? Don't just watch the YouTube videos and go and try to create an understanding just off a YouTube video. Also at the same time, not just off of books that you read, go and actually do the reading. When you read that book or when you hear something mentioned in a YouTube video, go look at it, okay? And if I speak from a perspective of my understanding, go read it from that perspective. Don't read it verbatim and say, well, I don't know if that's really sounds exactly like how he says it. Well, thing is, maybe you don't understand it. Okay, the definitions and understanding sometimes can misconstrue you because you don't know certain words and how they kind of link together, and they put things in certain ways that kind of confuse you. Okay, so it does take a deep understanding. It does take to understand how the Constitution is written for you to understand how they communicate things. But once you kind of get it, then it becomes easier to understand, and you have more of an overstanding versus a understanding. Okay, I already talked about how the fact that the U.S. Constitution, Article 1, Section 10, says that private contracts are protected and can override statutory obligations if done lawfully. Dig me? So if you want to overcome some statutes in your state, or you want to overcome state law, and again, it's not legal advice, go through your trust. And you don't have to have a SESKV, trust and all of that, things that people will try to sell you on to do that. Create a private trust, and boom, you can go through this. Also at the same time, man, let's talk about the fact that you can still use the basic level of consumer law through your trust as well. Okay, if they ignore you, you have a right to use the FDCPA. They will be violating the FDCPA as well. Okay, because you can also validate debt through 15 U.S.C. 1692G. You can also challenge them on their communication. If you write them a letter, they must communicate back with you. You can also go to the aspect of asking them for full disclosure under 15 U.S.C. 1601 under the Truth in Lending Act. You can also challenge credit reporting under 15 U.S.C. 1681. Okay, and these are the things that most people don't talk about, because they think that if you go about it one way, then you can only go about things one way. Okay, you can settle debt on the public side, but you can also settle debt on the private side that may give you a different leverage and a different positioning and help you overcome some statutory limitations. Okay, it doesn't change the fact that you can do things on the public side, and don't think that you have to be stuck on doing things on the private side, but there is benefits of doing things on the private side. Okay, you just have to know your stuff. Okay, so essentially, let's talk about how to create and use a trust for debt. Okay, number one, create a private trust or entity. Use a declaration of trust or a contractual private membership association. Sign an EIN if needed, and never use your SSN. Okay, again, you can go online and pretty much get these things put in place. A lot of times people think that they need a lawyer to create a trust. Now, it does help because they'll be able to draft up those documents for you, but let's just talk about the difference between a public, and let's talk about the difference between a private trust. Now, the public trust is essentially going to be created with your state website. Okay, you can go on your state website and you can create a public trust. Okay, typically it's going to be registered with the state, often requires an attorney, and essentially the IRS expects regular filings, and essentially is used for estate planning and charities. Now, when we talk about the private trust, which is created under common law and under the contract law, it's not registered publicly, can be created using that declaration of trust or a PMA. The IRS involvement depends on your structure, and it is essentially used for asset protection, control, and privacy. So essentially, how to break that down is you would create that declaration of trust, okay, which is a private contract where you, the grantor, appoints a trustee to manage the property or responsibilities to benefit the beneficiary. Now, this is something that you can create on your own. All right, you don't file it with the IRS or the state, okay, and it's protected under the right to contract under the U.S. Constitution. Then you want to notarize it and proof it. You want to notarize it for proof and enforceability. Okay, this is that foundation document that you would use to essentially create that trust structure and give it power to handle debt, receive income, and hold assets. After you create that, then you will go to the IRS and get your EIN. Just because you get your EIN from the IRS doesn't mean that it becomes public, but when you do this, this allows you to receive income, send and receive mail, open a trust bank account, and issue promissory notes or settle accounts. Okay, so you would just go to the irs.gov, create your EIN, and essentially go elect a state trust whether you want to do irrevocable trust or other types of trust, depending on what it is that you want to do. Okay. So obviously, you may ask, okay, what comes first? You want to make sure to draft that declaration of trust. Then after that, and this is optional, you want to go and apply for an EIN through the IRS. And then essentially you use that trust to handle the debts, contracts, and assets privately. The aspect where you may need a lawyer is if you don't want to draft up these documents yourself. Okay, you can go online, maybe find a template and things of that nature, or have an understanding of the template and then write your own declaration of trust, your own debt assignment agreement, and your own tender of payment letter from the trust. Now, these are some of the things that I'll include in the complete debt guide as a resource. Okay, and I may not include it right this second, like right during this video, but I'll put that stuff together, throw it in the complete debt guide, and you guys can get access, or you can go online and find a declaration of trust. Okay, but if you want to get it all in one place, I'll put it in the complete debt guide. So I went through that pretty fast, but let's just break that down. Step one, create that declaration of trust. Okay, or a contractable PMA. Okay. Number two, you want to assign the debt to the trust. Okay. Create a debt assignment contract showing the trust as the responsible entity. Number three, you want to issue a tender from the trust, send a promissory note, private bond, or order of set off from the trust, include a letter referencing UCC 3-603, and then you want to demand full validation and standing from the trust, challenge the debt under the UCC and the FDCPA, demand proof of claim and contract and lawful consideration. If you go through these 4 steps, you can be able to challenge debt, settle debt through a trust, private trust specifically, and you want to make sure that it's private so that you can overcome those state limitations. And if you do this, this will put you in a better position, a better negotiation power to be able to settle and challenge debt, also at the same time discharge debt. Now, for those of you guys that got all the way to the end, make sure to understand that this is not something that you always have to do, but it is a good tool if you know how to do it. Okay, if you understand, you're willing to do the due diligence and understand the aspect of, operating in the private, then go ahead by all means. This is not legal advice. This is me giving you the information in the game that nobody wants to talk about, but they'll charge you thousands of dollars to do. And again, I'm giving it to you for free because anybody can look these things up online. Anybody can do a simple search. Anybody can do these things and nobody wants to do it. They're going to make it seem like it's a mystique, but there's no mystique. You dig me? There's none of that. So if you got all the way to the end, make sure to comment that word discharge. Okay, if you comment the word discharge, I know that you're a real one. Okay, now understand. Now you don't have to fight debt as a powerless individual. With the right of trust or private structure, you can take control of your legal identity, protect your assets, and settle debt with private law. This isn't a theory. This is actual strategy. Okay, this is a strategy that you can essentially use to be able to move forward and also at the same time get above and be able to go and grow in this economic system. Okay, don't just take it from me. Do your due diligence. I don't care if you watch this video and you say, look, man, I don't believe anything in a word that you said. Just go online and look it up. To be honest, I really don't care if you believe me or not. You dig me? I went, did the due diligence, and I found the proof. Okay, don't think of this as some type of mystique, some type of conspiracy theory. It's none of that, because if I can go online and find this information, so can you. Okay, and the information is out there. It's just the conspiracy aspect is the fact that they don't want you to believe that it's true. And it's not just coming from people in the comment sections. The banks want you to believe it's some type of theory, some type of conspiracy, but it really isn't. Okay, it's actual real application of these things. And if you have a full understanding, you can pretty much take advantage of any situation to your benefit. Okay, you are the beneficiary. You got to start acting like it. All right. Now, if you want that private trust template, a full debt settlement walkthrough, go ahead and tap in with the complete debt guide. I have a whole discharge kit in terms of letters, resources, jargon, but also at the same time instructions for the full debt validation process. I update that. This is my hub where I update and add new resources for my YouTube videos. Also at the same time, a lot of people is asking, hey, is this a brochure? Is this a packet, a book? It's all of that in one. I mean, it's really a course instructional course with videos of me explaining this information to you, but also at the same time, it has resources. Okay, not only my resources, but resources that I've gathered in terms of templates, resources that you can find online. All right, if you do some real digging, but I packaged it and put it all in one place. Okay. Also at the same time, letters that I create for my YouTube videos, I'll put it in the complete deck guide and it'll be updated on a consistent basis for only 47 bucks. Okay. Right now it's 47 bucks one time, but the more and more value that brings up, this is probably going to be more something that people will have to pay monthly for as much as I update it on a consistent basis. If I continue to keep making videos like this, then this is probably something that I'll change the pricing of it, because for me to sit down, create the videos, then also at the same time create templates for the things that I'm teaching you guys and giving you guys some type of instruction and guidance on top of that, man, $47 is a steal. Okay. At one point, this guy wasn't even half the price it was. Okay, this guy ranged from 97 bucks to 200 bucks to almost 500 bucks, and there are people who spent that type of money. But even if they spent that type of money, it doesn't matter, because I continue to update this. Anybody who has spent that money and now sees it for $47, they'll tell you that it's a steal. Okay, so go ahead and tap in with the complete debt guide. The link will be in the description. Number two, if you want that one-on-one mentorship, this is not for debt discharge. If you are a person who have debt that needs to be discharged, you want to learn more about the consumer law aspect, just spend the 47 bucks, tap in with the complete debt guide. Okay, because that one-on-one mentorship is something that is going to be a premium service for people who actually want to fix their credit, people who actually want to get funding up to 6 figures or more, people who actually are entrepreneurs and business owners who want to grow and scale their business. Do not apply for my mentorship if it is something that you are hoping to get on the phone with me, and I'm gonna give you all the consumer law game that I teach in these YouTube videos. If you're not there to get a premium coaching and private coaching experience from me, and you're looking to learn more about debt discharge, just tap in with the YouTube videos and tap in with the complete debt guide. Also at the same time, check out my Instagram if you want more private law, more consumer law, more credit game, more funding game, more business game for free. Tap into the Instagram at biz.nick. The link will be in the description as well. Last question I have for you. Have you ever thought of using a trust to handle debt? I know you have. So drop down in the comment section for those of you guys who have already have done this, for those of you guys that are looking to do this, and let's talk about it. Any questions that you guys have, go ahead and put that in the comment section down below. Make sure to like, comment, and subscribe. Turn on the post notifications. And for those of you guys that have got all the way to the end, if you haven't already, comment the word discharge, and I'll see you in the next one.